Hello and welcome back. I understand that there were some technical issues with my second torts video, so I'm just going to prepare this supplemental video. It shouldn't be very long. I just want to cover the negligence tort, the tort of negligence. Um, there, it's important to know, before we covered intentional torts, and that's when the defendant not only intended the act, but also the consequences. With negligent torts, the defendant intended the act, but they didn't intend the consequences, although they should have. And that's really the big issue. And that's really the million-dollar question. Just because you've been injured because of someone else's carelessness doesn't mean necessarily that you would have a successful lawsuit. Now, the law implies that we all owe each other a duty of care to act reasonable under the circumstances. So with that in mind, negligence cases always have four elements. Just like disparagement and defamation, they have elements, and unfair competition, all those intentional torts that we talked about before. Negligence also has elements, the first of which is a duty of care. That is, the law has imposed some kind of legal obligation on the parties to behave in a certain way. I'm not going into greater detail of all of them. After I put them out. So a duty of care. 2, there's got to be a breach of that duty of care. 3, there has to be proximate cause. What that means is it's the legal cause, not necessarily the factual cause. With the legal cause, what we mean is there's a close connection between the defendant's behavior and the plaintiff's injuries. Finally, 4th, damages. But that's always the case with all personal injury lawsuits. You always have to prove damages. All right, so let's talk about the first one, a duty of care. What that means is, again, the law has imposed a legal obligation on the defendant to behave in a certain way. Well, that's actually more art than it is science. There are factors, however, that courts will look at in determining whether or not to extend a duty of care. The first of which is control. Did the defendant have control over the situation? For instance, there was a case, Polka versus Edelman. It was in New York. It involved a pedestrian. She was hit when the driver of a car pulled out of a garage in New York City, in Manhattan. Now, the driver of the car was also the owner of the car. What had happened is the driver had presented her ticket. The parking attendant went, got the ticket, got the car, and brought the car to her. While they were still inside the garage, the attendant got out of the car, handed the owner of the car the keys, and that was it. The owner then proceeded to drive out over the sidewalk, hoping to make a turn onto the street, and that's when she struck the pedestrian on the sidewalk. Well, the pedestrian sued the garage. Now here, what's really the issue? Did the garage really have any control over the situation? No. They had none whatsoever. At that point, they had given the car back to whom? The driver, the owner. So it wasn't. Now, obviously, maybe the facts would be different if what? If the attendant had driven the car out into the sidewalk before giving it back to the owner. But that was not the case. So control, that's a big one. Another factor that's important is whether or not the defendant was on notice of the condition. Now, there are 2 types of notice. There's actual notice and there's constructive notice. Now, actual notice is when the defendant really knows about the dangerous condition, but they fail to take any steps to fix it. A great example of that is one of my favorite companies, the Big Apple Pothole Company. Now, it used to be, before the Big Apple Pothole Company, that if you were injured walking on a sidewalk or a street in New York City, any of the 5 boroughs, and you would try to sue New York City, one of their defenses was, we're not on actual notice of that defect. Well, a bunch of attorneys got together, and they decided, you know what, we're going to put the city on actual notice of every defect. So every year, the New York City Pothole Company hires an army, a small army, to scour every street, every sidewalk, in all 5 boroughs. And they have basically a map. Each individual is given a little map. They usually hire college students, I think sometimes high school students, depending on their age. And they're given a map. And what they do is they go down the street, and as they're going down the street, they're marking off where there are defects. Now, there are different symbols for different types of defects, but as they're going down the street, they're marking it off. You know, this is a depressed sidewalk, this is an uneven curb, and they're just making the symbols all along the way. The Big Apple Pothole Company takes all those little maps and compiles them into one big map. Then once a year, the Big Apple Pothole Company goes to Corporation Counsel. They are the attorneys for the City of New York, and says, here you are, City of New York, you are now on actual notice of all these defects. So, and the way the service works, just in case you're curious, you don't need to know this for any kind of test or anything, just, you know, these are great ideas. Suppose I'm an attorney, suppose I have a client who claims that she was injured, you know, walking down some street somewhere in New York City. And I want to know if the city was on notice. What I would do is I would make a request to the Big Apple Pothole Company. I pay them actually a very modest fee. And they would send me that map of the location where my plaintiff fell. I would tell them where she fell, and they would send me the map for that street and the surrounding area, so I can tell whether or not the city was on actual notice. The other type of notice is constructive notice. Now that's a little bit harder to establish. That means that the condition has lasted for a long enough time that the defendant should have known about it. That's tough to prove sometimes. A good example of how difficult it is to prove, from the school, I walk to Penn Station, and I go down the stairs. Now suppose, you know, oftentimes on the stairs, what might you find? Litter, paper, plastic, whatever the case may be. Sometimes there's a bottle. Now what if I were to step on something and be caused to fall down and injure myself? Well, I could try suing, but what is it about litter? Is litter like a permanent condition, or is it really a transient condition? It's really a transient condition. Litter, it could just be blown in maybe a minute before. Establishing constructive notice that Penn Station should have known about that litter is pretty difficult because of the transient nature of it. It might be easier to establish constructive notice of a recurring condition, you know, like a leak that just can't seem to be fixed. There's one of those in Penn Station as well. When it rains heavy, there's always water leaking right in front of the McDonald's. So, and they usually do have it blocked off. But you know, maybe you can make the argument it was raining and they should have blocked it off sooner rather than later. You know, they were on constructive notice of it. They should have known about it. So basically, the issue there with constructive notice is the condition has lasted for a long enough time that the defendant should have known about it. All right, another factor, so far we have control, we have actual or constructive notice. Another factor that courts look at in determining whether or not to extend a duty of care is whether or not the defendant's actions were active or passive. Now, which one do you think a court is more likely to extend a duty? Well, active. If you're doing something, you should do it carefully. That's kind of the starting point. If the defendant's actions are passive, it's a little bit harder. You're saying that they should have done something. Implicit in that should have done something is really a moral obligation. And courts have been hesitant to turn moral obligations into legal obligations. One case involved, for instance, a cinder block in the middle of the road. A pedestrian walked by and didn't do anything with the cinder block, and of course what happened, the car hit it and was in an accident. You don't have a legal obligation to clear debris from a road. I mean, should you? Yeah, you probably should. Someone's going to get hurt. But you don't have that legal obligation to do it. A very controversial case, which I spoke briefly in the other video, Osterlin versus Hill. A very controversial case, 1928, Supreme Court, Massachusetts. in a nutshell, basically, the defendant was being sued. Why? Because he watched as a man drowned to death in a lake. And so the estate for the deceased sued the defendant. And it was established that the defendant was actually a really good swimmer and probably could have saved the man from drowning with very little risk to himself. But the court there was hesitant. It did not want to extend, turn a moral obligation into a legal obligation. Obviously, that case was, in fact, very controversial when it came down. But again, that's the difference between passive versus active actions. Courts are more likely to determine that there's liability if it was active, if the defendant's conduct was active. Another duty is the risk.
There's an interesting case. The name of the case was Palsgraf versus the Long Island Railroad. This is a case that has been studied over and over and over again. For those of you who might be interested in law school, you're going to get to know that case really well. Basically, in a nutshell, Mrs. Palsgraf, she was waiting on a platform for the Long Island Railroad. She was up against a wall, just waiting for her train. As she was waiting for her train, down the platform, quite a ways actually, was a man, and he had a couple of packages in his hands, and he was having difficulty going up into the train. So two Long Island Railroad conductors decided to help him. One was inside the train, pulling him in. The other was outside the train, pushing him in. Well, all this pushing and pulling caused him to drop the package. Now, this is important. The packages were sealed at that time. The conductors didn't know what was in it. One of the packages fell, and lo and behold, what was in it? Fireworks. One of those fireworks exploded, some kind of bottle rocket. It went across the platform to where Mrs. Palsgraf was standing. The bottle rocket didn't hit her. The firework didn't hit her. What it did actually was hit a scale or a clock that was directly above her, and then it fell down and hit her on the head. In that case, it went all the way up to the Court of Appeals of New York, and the Court of Appeals held that basically the Long Island Railroad didn't have a duty to poor Ms. Palsgraf. One of the things they cited was the risk perceived defines the duty owed. In a lot of senses, it's kind of like actual notice. But here, maybe the case would have been different if what? If the package had been unsealed and the conductors could look in and see the fireworks. That might be, that may have been the difference in the case, or possibly a difference in the case. So those are some factors the courts look at. Other things that the courts look at include risk versus the cost of avoiding the risk. That's a big factor that courts look at. And a great example of that is diagnostic testing. Breast cancer. Breast cancer is a big health issue for any woman. And although mammograms won't prevent breast cancer, what do they do? That's very important. They help in the early detection of breast cancer. And if breast cancer is detected earlier, it makes your chances of survival that much greater, and quite frankly, the cost of treatment that much less. And how much is a mammogram, really, in comparison? Late-term breast cancer, poor rates of survival, expensive treatment, versus early detection, much greater risk, much greater chance of survival, less invasive treatment, by the way, and also a lot less expensive. Well, risk versus the cost, it's not even close. Go get the mammogram. And that's why doctors, who are often criticized for sending their patients for, quote, unnecessary diagnostic tests, do that. The cost of a diagnostic test is $600-700, maybe a little more, maybe a little less. But compared to what you could potentially be preventing,
or detecting at an early stage, it's not even close. The expense is not even close. I think that diagnostic tests, for the most part, save lives and save money, quite frankly. So risk versus the cost of avoiding those risks. That's another factor that courts look at. Courts also look at policy. What's good policy? Just in terms of human behavior. That's something else, another factor they may look at. All right. The next factor, very important in negligence, is a breach of that duty. Okay? That somehow the defendant breached that duty. And you really need a lot of evidence to do that. You got to make sure you do your due diligence. If there's an accident, you go down to the site sooner rather than later, and you take pictures and maybe get a witness statement, stuff like that. There's got to be a breach of that duty, but more importantly, the breach of that duty has got to be the proximate cause of the plaintiff's injuries. What do I mean by that? There's got to be a close time and space connection between the plaintiff's injuries and the defendant's actions. So, for instance, suppose on my way to school, I'm waiting at a red light, and I get hit in the rear, and my car is totaled, and I have to be taken to the hospital. Well, certainly the cause, in fact, was the driver. But could I? I mean, this is an exaggerated example. But could I sue the mother of that driver? After all, had she not given birth to that driver, I would have what? Been all right. He would not have had an accident with me. That's an exaggerated example. The point is, that's too far removed. It's too far removed. But for the fact that she gave birth to the driver, he would not have hit me. That's too far removed. So there's got to be a close causal connection. Related to that is really the issue of foreseeability. What was foreseeable in terms of proximate cause? And apply to our example, was it foreseeable for the mother that at some point her offspring would cause a tremendous motor vehicle accident and injury and whatnot? Probably not. I mean, foreseeability. Would a reasonable person have foreseen the consequences? If so, then you probably have proximate cause. All right. Last but not least, damages. You have to have damages, and we talked about that the first lecture. It can be compensatory damages or punitive damages. Know the difference. Okay, that's it for this video. I hope that it loads up properly. Thank you.